Good morning, everybody, and welcome to this memorial lecture. We'd like to start this morning's program by lighting of the lamp. May I request the dignitaries on the stage, and may I also request Ms. Ami Desai. The Honorable Mr. Justice Ashok, Justice Revati Mohite Dere, Justice Gautam Patel, judges in the audience, my friends, welcome to the third Ashok Desai Memorial Lecture hosted by the Bombay Bar Association. I'd like to start the morning's program by calling upon the President of the Bombay Bar Association, Mr. Nitin Thakkar, to give his welcome address. Mr. Thakkar.
The Honorable Mr. Justice Ashok, Judge Supreme Court of India, the Honorable Mrs. Justice Revati Mohite Dere, Judge Bombay High Court, Justice Gautam Patel, former Judge of Bombay High Court, present Judges of Bombay High Court, Justice Sri Krishna, Justice Mrs. Manohar, former Judges of Supreme Court, Justice Ajit Shah, former Chief Justice, senior advocates, members of the Bar Council of Maharashtra and Goa, family members of Sri Ashok Desai, members of various bar associations, teachers of law colleges, law clerks, law interns, and law students, ladies and gentlemen. A very good morning to you all. A very warm welcome to all for coming today for third Ashok Desai Memorial Lecture to be delivered by Honorable Mr. Justice Ashok on what ails our criminal justice system, some thoughts. We are indeed grateful to you, sir, for having very kindly agreed to deliver the lecture. This lecture is going to be very useful to members of the bench and bar alike. We are also thankful to Mrs. Justice Mohite Dere for having agreed to preside and deliver presidential address. Justice Gautam Patel, who started his judicial innings by sharing bench with Justice Ashok, has agreed to introduce Justice Ashok and Ashok Bhai. Who better than him? Sir, thank you very much for doing the honors. The lecture series has started in memory of Sri Ashok Desai. We hold every 2 years in Bombay and every 2 years in Delhi. We are indebted to Mrs. Suvarnaben Desai for a very generous donation to Bombay Bar Association Trust. She took very keen interest when the inaugural lecture was organized, giving her valuable inputs from hall decoration to even menu. The family members Harsh, Ami and Jai have taken over from Suvarnaben in taking interest in organizing this lecture. Ami and Jai have specially come from USA. A big thank you to entire family of Ashok Desai. I welcome each and every one of you and thank you for coming today. And I assure you that you will be richer at the end of the session today. Thank you very much.
Thank you, Nitin bhai. Before we start the lecture, I'd like to call upon Mr. Venkatesh Dhond, the Vice President of the Bombay Bar Association, to present a small plant to Justice Oak. I'd also like to call upon Ammi Desai to give a memento to Justice Oak. Next, I'd like to call upon our committee member, Kainaz, to give a small memento to Justice Revati Dere Moite. And also Jay. Can I call upon our committee member Swanand Ganu to present a small memento to Justice Patel? And Harsh Desai on behalf of the family. Thank you, Harsh. I'd now like to call upon Justice Gautam Patel to give the introductions. Justice Patel.
Justice Oak, Justice Revati Mohite Dere, Honorable Judges, past and present and, dare I say it, future, Mr. Thakkar, Mr. Dubash, members of Ashok Bhai's family. A very good morning to all of you. It is a special privilege to be here today and to be given this small window of opportunity. I have, as it happens, something of a triple, or as judges love to say, threefold justification for being here. I just happen to have been close to all three, Ashok Bhai and his family, Justice Oak, and Justice Mohite Dere, for a very long time. Ashok Bhai's and Suvarnaben's association with my family goes back not just decades, but generations. Ashok Bhai's parents were close to my maternal grandparents. My own memories are many, predating our association in law, shared family holidays in Khandala and Mahabaleshwar and more. Incidentally, on that, let me assure you that for all his many other sterling qualities and achievements, Ashok Bhai was a truly terrible motorist. In his case, it was a triumph of confidence over ability, or even caution, and the phrase dying declaration took on a totally different color as he swept up the Mahad Ghat with complete indifference to oncoming traffic. I will not take your time today with a full-blown introduction to Ashok Bhai. That could possibly take hours. Ashok Bhai, the preeminent lawyer, The list of landmark cases alone is a long recitation across an astonishing range of issues, from Sakharam Binder to Back Bay to Antule and beyond. A master of courtcraft and of reading a bench, a man of wide and eclectic reading, a traveler, passionate about music from, unbelievably, opera to Hindustani classical music, a follower of the arts, fiendishly clever, and blessed with a wicked sense of humor, a friend to everyone, and not an enemy in sight. How could it be otherwise with someone who read and loved everything from ancient texts to Shakespeare and Woodhouse and modern thrillers? Many here will remember his cheerful come along, an open invitation to a salon-like soirée at his home, surrounded by books and objects, the conversations ranging with as much knowledge as laughter over a wide range of topics. As a junior, I got to work with him, and I'll only say this. He was that rare breed of lawyer of whom it could be said that you never went into a conference or a hearing with him without coming away having learnt something new. I believe I was also privileged in a different way when I had to appear alone against him in what was literally my first appearance in the Supreme Court. We were before a formidable bench headed by Justice Chinnappa Reddy. My senior had to leave Delhi. He told me to carry on. I was terrified. On the other side were Ashok Bhai and Tempton and Dhyarujina. My senior told me not to worry. They would, he assured me, look after me. I couldn't understand that. A tense and sleepless night later, I had to go into bat. Ashok Bhai and Tempton were indeed opposing, both preternaturally calm. At some point, Ashok Bhai, a foot or so away, touched my arm and whispered to me to slow down and take my time. I looked at him in surprise and then recalled what my senior had explained. With Ashok, he said, when it comes to a junior, he is never on the other side. Here's the thing. He wore all his successes, everything from an honorary doctorate to wealth to the Padma Bhushan, lightly and with a self-deprecating wryness. That is not surprising when you remember that he truly embraced the core of Buddhist teaching. Ashok Bhai's father, Hari Bhai, was himself a lawyer of renown at the criminal bar. Throughout his career, Ashok Bhai maintained, as he once said to me, at least a familiarity, if not greater intimacy, with that branch of the law. It is therefore superbly appropriate that we have with us today Justice Abhay Oak. I am not going to introduce him either. For me, personally, that would take a very, very long time indeed. From a colleague at the bar, to a mentor on the bench, to what we are today, the closest of friends, and I mean that sincerely, as friends who have seen each other through seemingly impossible times, I believe our relationship defies description. It transcends this concept of brethren and has evolved into something more. Abhay, forgive me, it's very hard to go down the justice this and justice that route. Set for many of us on the bench the gold standard in judicial work, it was thoroughly intimidating until you cottoned on to the realization that all you could do is sit back and admire his tenacity, his capacity, the ferocity with which he worked, but never match it. And this has gone on for, unbelievably, 22 years without respite. But there are shades to Abhay's thinking that demand closer study and analysis for a fuller appreciation. Foremost amongst these, I believe, is his unwavering commitment to personal liberty, justice, and the guarantees in Part 3 of our Constitution. He is not the kind to proclaim or advertise or justify his own work, give interviews. He carries on with his writing, decision-making, and thinking. He just goes out there and does it. The way he handled the Karnataka High Court on the administrative and judicial sides, especially during COVID, is an example. And I think above all, during his tenure in the Supreme Court, there is his undeniable contribution in criminal prudence. Almost single-handedly, he has found ways to quietly steer that back onto track, to keep it aligned firmly with constitutional precepts, and to literally subvert from within all attempts, judicial and executive, at distortion and the deprivation of citizens' rights. I am sure his address today on the criminal justice system in this country will be revelatory. Finally, to Justice Revati Mohite Dere, I am and always have been, I'm not at all sorry to say, that creature of a special stripe, an elder brother who is as frequently annoying as he is like-minded. And for me, she is a sister beyond the bench, entitled to tease, mock, and sharply criticize, the kind of sister you unhesitatingly cross continents for. Actually, I don't recall an issue on which she and I have not been completely aligned. Her commitment to justice is not narrowed by age or gender. Like Abhay's, it is guided by a fundamental and even instinctive understanding of justice and liberty. What is the right thing to do? She carries this beyond her work in a court of law. She is not an overt disruptor. She is one who instead quietly transforms. Leaving aside judicial work, you should see what she has pulled off at the remand home, at various family courts, and more. And all of this with one solitary, immutable objective in mind: doing what is good and necessary for those who need it most. I look forward to her address too, as I am sure you all do. Thank you for giving me this time to say a few words today. To Ashok Bhai, I can only say this: I am only one of very many who miss you each and every day. Thank you.
Thank you, Justice Patel, for those words. I'm sure they will set the tone for the remaining speakers. Next, I'd like to call upon Justice Revati Mohite Dere to give the presidential address. Justice Dere.
Justice Ashok, Judge, Supreme Court of India, my colleague, Justice Gautam Patel, former judge of this court, Mr. Thakkar, President of the Bombay Bar Association, office bearers of the Bombay Bar Association, Justice Sri Krishna, Justice Sujata Manohar, former judges of the Supreme Court, Justice Ajit Shah, former Chief Justice of the Delhi High Court, family members of the Ashok Desai's family, senior advocates, ladies and gentlemen. It is both an honor and privilege to stand before you today on the occasion of the third Ashok Desai Memorial Lecture, an annual event that pays tribute to an eminent legal luminary, Sri Ashok Desai, popularly known as Ashok Bhai. This event is a testament to his indelible contributions to the legal fraternity, his unwavering commitment to justice, and his relentless pursuit of excellence in the field of law. In the words of Henry Wadsworth Longfellow, when a great man dies, for years the light he leaves behind him lies on the paths of men. Ashok Desai, a giant among lawyers, had a remarkable career spanned over 5 decades. Throughout his illustrious journey, he argued several landmark cases that have shaped the country's legal framework. His mastery of the law, combined with his exceptional advocacy skills, earned him respect and admiration of his peers and the judges. He was a true master of the courtroom and an officer of the court. Ashok Desai's contributions to the development of constitutional law, administrative law, criminal law, and competition law are immeasurable. He was a pioneer of the constitutional law, and his arguments in several landmark cases helped shape the country's constitutional jurisprudence. His expertise in administrative law helped establish important principles governing the relationship between the citizens and the state. He was highly respected in the Indian legal community, known for his exceptional advocacy, skills, and his commitment to upholding the Constitution and promoting the rule of law. Some of the landmark cases in which Ashok Desai appeared that shaped the country's legal framework, to name just a few, were Sakaram Binder, Pilu Modi, and Vineet Narayan. As all of you know, Sakaram Binder was a case that struck down the pre-censorship of dramatic performances, highlighting the importance of freedom of expression. Pilu Modi was a case that advanced the proposition that land belonged to the state must be treated as being held in public trust and must realize a fair price. Vineet Narayan was a case that dealt with the powers of a court to monitor investigations against political leaders, emphasizing the need for accountability and transparency in governance. Ashok Desai's illustrious career saw him hold several prestigious positions. He had the unique distinction of being both a Solicitor General of India and an Attorney General of India. He was awarded the Padma Bhushan and, of course, several other laurels. During the 3 decades in Delhi, Ashok Desai was a go-to senior counsel for the aggrieved citizens, celebrated corporate clients, and public authorities alike. He was consulted by presidents, prime ministers, regardless of political color, by professors and journalists, traders and trade unions. Ashok Desai was a strong advocate for social justice and human rights. He appeared in the Narmada Dam case, which considered the grievances of those who were affected by the dam's construction. His legacy extends far beyond his impressive professional achievements. He was a kind and generous soul who always had time for his colleague, friends, and family. He was a great mentor to many young lawyers, and his guidance and advice helped shape their careers. As someone who knew Ashok Desai very closely said, Ashok Desai was a man with the soul of a monk and a heart of a king. Ashok Desai was a person of eclectic interests and a commitment that traversed several fields of public activity. As Gautam also said, he was a connoisseur of classical music. I am told many a briefing was made much more enjoyable with Hindustani or Western classical music playing in the background. Ashok Desai was popular for his repartee and wit, and poetry and quotes laced his legal submissions. Ashok Desai's keen intellect, persuasive advocacy, and unyielding integrity continues to inspire generations of lawyers and judges. His legacy serves as a guiding beacon, reminding us of our duty to uphold the rule of law and ensure justice for all. He earned a reputation as a fierce defender of civil liberties and a prominent proponent of constitutional values. This memorial lecture is in memory of Ashok Desai's legacy and the values that he believed in. Today, Justice Abhay Oak will deliver the lecture on what ails our criminal justice system, some thoughts. The topic is both timely and significant, given the challenges that confront our justice system today. The criminal justice system serves as a bedrock of democracy, ensuring the protection of rights, upholding the principles of justice, and maintaining social order. As Martin Luther King Jr. said, the ultimate measure of a society is not where it stands in moments of comfort, but where it stands at times of challenge and controversy. It is no secret that our system faces numerous challenges: delays in trial, overburdened courts, under-resourced investigative agencies, overcrowded jails, and issues relating to access to justice. These hurdles impede the very purpose of the system and over time may lead to erosion of public confidence in the rule of law. We need to overcome these hurdles which stare us in the face. One of the gravest issues plaguing our criminal justice system is the delay in trials. Sometimes this delay inures to the benefit of the accused. As a result of the delay, the witnesses may turn hostile. The witness protection scheme needs to be more robust. A staggering number of under-trial prisoners continue to languish in jail, awaiting justice. Criminal appeals in the High Court are pending for years. The inefficiencies in criminal investigation, often marred by poor training, lack of technological advancement, and external influences, further cripple the system. The need for reforms in policing, forensic sciences, and investigative procedures cannot be overstated. Without credible investigations, the prosecution case weakens, resulting in undue acquittals and prolonged trials which fail the very purpose of justice. Additionally, our judge population ratio is skewed. Courts across all levels remain heavily burdened with an ever-increasing backlog of cases, which, coupled with shortage of judicial officers, leads to further inordinate delays. The delay in justice delivery, especially in criminal matters, disproportionately affects marginalized sections of the society, aggravating inequality in access to justice. As John Kennedy said, the rights of every man are diminished when the rights of one man are threatened. Justice Oak's deep understanding of constitutional and criminal law, coupled with his extensive experience on the bench, makes him eminently suited to offer valuable insights into this pressing issue. Justice Oak has delivered landmark judgments touching upon the liberty of individuals. A bold judge whose passion and commitment to justice is known to one and all. It is in this context today's lecture assumes great importance and significance. It provides an opportunity to reflect and seek solutions that can enhance the efficiency and fairness of our legal system. As Chief Justice Warren Burger said, and I quote, "A system of justice is the infrastructure of democracy." It is imperative that we all strive to address these challenges, ensuring that justice is not only done, but is seen to be done. I know all of us, just as you are waiting to hear Justice Oak, so am I. And in conclusion, I would like to thank the Bar Association, Bombay Bar Association, for inviting me to preside over this function. Thank you so much.
Thank you, Justice Dere, for those insightful words. I'd now like to call upon Justice Abhay Oak to give the address. Justice Oak.
Sister Revati and other sister judges of the Bombay High Court, brother judges of the Bombay High Court, Nitin Bhai Thakkar, President of the Bombay Bar Association, other office bearers, Justice Gautam Patel, Justice Sujata Manohar, Justice Sri Krishna, and Justice Ajit Shah. I am so happy that I am able to speak in presence of Justice Ajit Shah, from whom I have learned lessons of judgeship. We have retired judges here and very distinguished senior advocates from whom I have learned so much as a lawyer practicing in Bombay High Court and thereafter as a judge of the Bombay High Court. There are young students, few young members of the bar I see here. When Nitin Bhai called me to invite me for this function, I accepted because everybody holds Ashok Bhai in great esteem. Only one part he said was disturbing when he said that Gautam Patel is going to introduce me. Because I had troubled him so much on the bench. So I had always that threat. In fact, about 2 months back, we shared a dais on leaflet function when Professor Upendra Bakshi was there. So I was tense throughout the function, but I did not get any awkward question from him. So memories come back. A day before Justice Gautam Patel was sworn in, I received a call at 10:30 in the night. He said, I want to ask you something urgently. I said, what is that you want to ask me? He said, I have received about 8 bags full of files. What I am supposed to do with these files? So I told him that you have to read those files. This was scare number 1. In those days, he was sitting with me. He was, I think, 10 days or 15 days old judge. In those days, I had some problem with my vocal cord. So at 5 o'clock, I had kept about 30 urgent matters for production. And I almost lost my voice. I told him, "Arey brother, I lost my voice." So he said, "We'll rise." I said, "No, we'll not rise. Now you dictate all the orders." But one good thing I must say about him is that he was the only judge who compelled me to laugh while sitting on the bench. Because I always thought that, spending a couple of minutes on laughing is also not good. But he made me change my habit. And one more thing, we differed only on one aspect. That was on cost. Because I was a typical appellate side lawyer. My ideas about quantum of cost were different. But there, I could teach him something. I remember a case which was argued before us. It was under Urban Land Ceiling Act, 4th or 5th petition. So I wanted the lawyer to withdraw the petition. He won't relent. So ultimately, I dictated judgment. I looked at Gautam and asked in Marathi, "Gautam, kiti?" So he made signal 5. So I dictated 5 lakhs. He said, "I never suggested 5 lakhs, I suggested 50,000. And as luck would have it, that order was confirmed by the Supreme Court. So it's a matter of great honor for me to deliver a lecture in the memory of late Ashok Desai, one of the greatest lawyers which Bombay Bar has produced. Earlier speakers have said so much about him. I'm not going to devote more time to that. About a year back, I had to deal with a case on the judicial side in the Supreme Court about the freedom of speech and expression. While making research, I came across a very beautiful article written by Ashok Bhai. The title of the article is Censorship and Sakaram Binder. I'll request everybody to read that article. What is said in the article is very, very interesting and very relevant. Just a glimpse of it I want to say. He was referring to certain judgments under section 292 of the Penal Code. And what he says is very interesting. He says, the principles in present code, if applied without discrimination, might also bring within their mischief Anna Karenina and parts of Mahabharata also. Then he says something very interesting about censor board, of course in the context of the famous drama, Sakaram Binder. He says that one of the most curious features of the whole approach of the censors is that unlike the artist, they are obsessed with sex. It's a beautifully written article and it continues to be relevant even till today. Only one thing I want to share for the benefit of young members of bar or those who are not so young, which is very relevant in today's day contest. You remember that he appeared for two socialist leaders in a petition filed by them, and ultimately the petition was allowed, as a result of which one of the chief ministers of Maharashtra had to step down. After so many years, I had occasion as a lawyer to advise one of the two petitioners, a very eminent socialist leader. That leader told me something which is amazing. He said that, of course, Ashok Bhai appeared pro bono. In fact, that is reflected in the judgment of the appeal bench. I think Justice Ray wrote the main judgment. That all of them went to Ashok Bhai one day in the evening and they said, "Sir, we want to felicitate you. Please attend felicitation function." He was very firm. He said, "Under no circumstances I'll attend felicitation function. I had done my duty and I don't want to take credit for favorable judgment." It is so relevant in today's context when we see eminent lawyers coming out of the court after a verdict is pronounced, speaking to the media, taking credit for the judgment. Other day I saw a very peculiar scene where one lawyer, after coming out from the court, gave that V sign to the members of the media. This is most important thing which Ashok Bhai said, and I implore young members of the bar to follow him. Your job ends by arguing to the best of your ability, and you should never take credit. Now coming to the today's subject, I must say that I am going to express my personal views on the subject. I must also say that I am neither a scholar nor a jurist. During last 21.5 years, I am someone who tried to work hard within my own limitations. The views are necessarily based on my long tenure as a judge of the 3 constitutional courts, very long tenure of 21.5 years. And I am saying this that I am going to speak on the basis of my experience as a judge, because the truth is that when I was practicing for a fairly long time of 20 years on the appellate side of the Bombay High Court, I never appeared in a single criminal case. The reason may be perhaps no litigant came to me with a brief on the criminal side, but that's a matter of fact. And I must also hasten to add that as my judgments may be wrong, my views may be necessarily wrong. But it is time for me to express those views, and I have shared these views on many public platforms, maybe on few topics which I am going to cover. I know that statistics and figures can be misleading. All of us are cricket lovers. There was an Australian off-spinner in 50s. He used to bat at serial number 10 and 11, and he used to score about 5 or 10 runs and remain not out. But his average was 90, just below average of Sir Donald Bradman. But still, for today's subject, according to me, these figures are very relevant. Only these figures will tell us what is the enormity of task before us. Now, those figures are available on public domain on National Judicial Data Grid. So, total number of cases which are pending in India before our trial and district courts is something like 4.58 crores, of which 3.48 are criminal cases. Total pendency in different high courts in India is about 62.5 lakhs, out of which 18.25 lakhs are the criminal cases. In Maharashtra, in our district and trial courts, 54.9 or almost 55 lakhs cases are pending, out of which about 38 lakhs are criminal cases. In magistrates courts in Mumbai, we have more than 6 lakhs pendency. In Mumbai Sessions Courts, it is more than 46,000. In Bombay High Court, the total pendency of criminal matters is more than 1 lakh. And more importantly, on the appellate side of the Bombay High Court, the pendency of bail applications is 5,000. And in most of the leading districts in our state, like Mumbai, then Thane and Pune, the pendency of bail applications exceeds 1,800. This is only a glimpse of statistics which will tell you the enormity of tasks before our courts. the subject is very interesting. When I look at the figures and I look back at my experience as a judge, I can say that the ailments associated with criminal justice delivery system are too many. It's not only one. We celebrated 75 years of Constitution, but I have said this on public platforms that this is, as far as members of legal fraternity is concerned, this is not an occasion to celebrate. It is an occasion for us to introspect. We must ask a question to ourselves whether we have fulfilled the expectations of common man from the judicial system under our Constitution. Because before our Constitution, our judicial system was conducting itself under the British laws. If I ask that question to me, have we fulfilled the expectations of common man from the courts under the Constitution? My personal answer will be no. All of you know that so many rights are conferred under the Constitution, talking about in the context of criminal law. There is a concept of fair trial, which is part of Article 21. There are safeguards against the arrest provided under Article 22 of the Constitution. And today, when we have completed 75 years of existence of our Constitution, we'll have to candidly analyze how far our courts have protected these rights guaranteed under the Constitution. I may sound negative, but I want to say something positive also. We have a concept of fair trial. And I always say proudly when I visit the judicial academies or the law schools that I feel proud that our country gave even Kasab a very fair trial. That's the feature of our system. Today, in international seminars or national seminars, we keep on praising legal system in one of the Asian countries, especially in the context of commercial law. But look at the concept of justice on the criminal side of that country. There is no fairness. There are no rights which are available to the accused. So this is one thing about which we should be very proud. There are various aspects of justice delivery system on the criminal side. Firstly, I want to say about citizens who are victims of the offenses. As you know, barring few exceptions, any person can set criminal law in motion. If there is a cognizable offense, a victim can go to the police station and call upon the police to register offense. We can see from the cases which come before the court, it's not easy for a citizen to go to a police station and get FIR registered. Maybe traditional IPC offense, maybe offense under cyber law. It's very difficult. And therefore we see people coming to the courts, people coming under section 156(3) of CRPC. I'm sorry, I'm going to refer to old sections, sections under CRPC. I'm not going to refer to the new law, but sections are almost identical. So people have to go under section 156(3) to criminal court to get FIR registered. Somebody goes under section 200 by filing a complaint. Somebody takes recourse to remedy which is outside our legal system. Somebody takes local political leader to the police station because the police are not willing to register the offense. And people come to the writ court, though there are judgments, Sakeri was and other judgments, we say normally writ court should not issue writ of mandamus directing police to register first information report, but people are helpless. So imagine if a common man goes to the police station, he is victim of an offense, but he finds it very difficult to get the offense registered. Not everyone can afford to take legal remedy before the court, maybe before the court of magistrate or writ court, because those remedies he can't afford. And then this leads to abuse. As all of you know, that if there is a civil wrong, say arising out of a property dispute or a commercial dispute, if the litigant goes to civil court, he takes long time to get his dispute decided. And therefore now these property disputes and commercial disputes are given color of a crime, and then people go under section 156(3) of CRPC and get the offences registered. Of course, there are reasons and reasons for this. To some extent, there are difficulties faced by the police department. Their job is not only to investigate into the offences, they have to maintain law and order, they have to control agitations, they have to do so many responsibilities when there is natural calamity, and top of that, they have to face political pressures. Justice Gautam Patel's father, late Shirish Patel, had intervened in one of the public interest litigations before me. He, along with, I think, two retired civil servants. The issue was whether a person residing in slums in Mumbai has right to get water, whether that right is protected under Article 21. Startling data was placed on record by late Shirish Patel. The data showed that about 28% of the constables working in Mumbai police were staying in slums because they can't afford the housing in Bombay. So this is the state of affairs, that about 1/3 of the police constabulary in Mumbai, they are staying in slums. And we expect them to perform well, and we have high expectations from them. And as a result of whole thing, now there are so many petitions for quashing under section 482 of CRPC, under article 226 of the Constitution. All high courts are flooded with that. If you go to a division bench, which of Bombay High Court, which deals with 482 quashing petitions or 226 quashing petitions, the cases listed are in 3 figures. If you go to Allahabad High Court, I am not exaggerating, the cases listed are in 4 figures. Now, what are the judges going to do with this kind of figures? So, coming back to the plight of the victim, it's very difficult to get first information report registered. Another very important gray area in our system is, once informant or a victim goes to the police station, somehow he gets his first information report registered, he has no control over the manner in which investigation is carried out. Whether investigation is proper, whether investigation is defective, he has no control at all. And therefore, we get those petitions under Article 226, directing that investigation should be transferred from one officer to some higher officer. Investigation should be transferred from traditional police to CBI. In a lighter vein, when such petitions come before me, I ask only one question to them: are you sure that CBI will do better than traditional police? And most of the lawyers don't have answer to that. But still people come by way of those prayers. But everybody can't afford to go to High Court for getting the investigation done in his case to his satisfaction. So this is one area where we need to have some solution. We need to create a statutory framework or a grievance redress mechanism where a victim can go to that authority and request the authority to look into the manner in which investigation has been carried out. This is one gray area in our system. The misery of complainant or victim does not stop here. The investigation takes time. Then there are delays involved. And most crucial factor is, though we talk about witness protection, etc., neither the victim nor eyewitnesses get any kind of police protection. And in our system, in bigger cities, the trials would start, say, after 6 years, 7 years, 10 years, or even longer than that. In the meanwhile, there is no protection to the witnesses and to the complainant. Of course, under some of the new penal laws, we have a concept of vulnerable witness. But unfortunately, in our system, every witness has become vulnerable. I met a chartered accountant a few days back at Delhi airport. I knew him for a long time. I met him after a long time. He was flying to a city in India. He said, I want to make a strong protest. I said, what is that protest? He said that he had conducted some audit about 20 years back, and now after 20 years, I am supposed to go to a criminal court and depose. What can I depose now? after 20 years. This delay has many consequences. Human memory fades away. So after 10 years or 15 years of the incident, the witness has to appear before the court. He has to precisely remember what happened about 15 years back, and then he has to face very skilled cross-examination. And there is one more gray area, a grave area, I'll call it. In our system, there are 50, 60, 70 cases before the trial court, which conducts the trial. Witnesses come and go. I was told by one of the doctors, I attended a seminar conducted on human rights by Association of Medical Practitioners. So doctors told me that, sir, we have to visit the court at least half a dozen occasions. And only thereafter, someday, we are lucky and our evidence is recorded. There are different reasons for this. But this is very important. This is how our system treats the victim and witnesses. Now, there may be changes required in the statute and many other things. I'm going to talk about that. But let us see the other side. The accused. Now, we have those three well-settled principles that there is a presumption of innocence, then the guilt of the accused must be proved beyond reasonable doubt. Of course, there are now exceptions to that, maybe Section 139 of the Negotiable Instruments Act, 113B of the Evidence Act, presumptions, various presumptions under NDPS Act. And third and most well-settled rule, which I believe must be implemented very strictly, is that the bail is the rule and jail is the exception. I believe that even in case of statutes like PMLA, UAPA, the same rule will apply with some modification. I have said so in one of the judgments. Today, of course, I am not here to refer to any reported judgment or refer to specific provisions. But something basic which I want to point out, if you read Section 41 of the Criminal Procedure Code, the concept is very fundamental. It is not necessary for police to arrest each and every accused. Even in case of offense where punishment is for more than 7 years, there are two conditions. One is that information received by the police must be credible, and the police officer must have reason to believe on the basis of that credible information that the person has committed an offense. And this is only enabling provision. This does not make it mandatory that in every case accused has to be arrested for the purposes of investigation. There are other provisions in CRPC and now BNNS that presence of the accused can be procured for investigation by issuing a summons. But what happens at grassroots level is different. Law is very clear. It is not mandatory that every accused should be arrested. In a given case, police or the investigating officer may be of the view that it is not necessary to arrest the accused. But then there is a lot of pressure exerted on him. He may be of the view that he will procure the presence of accused for investigation. That will be sufficient for him to conclude the investigation and file a charge sheet. But there is a pressure exerted on the police machinery by citizens, by NGOs, by media reports. There are political leaders who go public and say that will ensure that accused is arrested and he is put in behind the bars and he will not get bail. There are such statements issued by the political leaders. Now, why this is happening? Many reasons are there. One is a perception that police are not doing their job. But my personal view is that this is a sad reflection of retributive tendencies which are still present in our society. Common man presumes that once a person is named as an accused, he is the one who has definitely committed the offense. And the result of whole thing is that today we have a scenario when in jails in Maharashtra, 80% prisoners are under trial prisoners. 80% is so high. And I think I saw figures published by NALSA. I think overall it is something like 60%. 60%, if you take all India average, 60% of those who are detained in our prisons are under trial prisoners. Then comes very important thing, once a person is arrested, then one battle starts for him, that is right to get bail. Firstly, he has to find out a lawyer whom he can afford, a lawyer who has reasonably good knowledge of the criminal law. Then the second issue starts from listing. In fact, if you see 437 of CRPC, even the courts of magistrates have power to grant bail. But today we have a scenario where in a magistrate tribal case where a charge sheet is filed, people have to come to Supreme Court for bail. Very rarely that people get bail in such cases, even from the courts of magistrates. So on paper there is a power under 437 to grant bail in certain cases. It remains on paper. Then everybody has to rush to the Sessions Court. Getting cases listed before Sessions Court may not be a major issue, but getting the cases bail application decided is a major issue. We have shortage of prosecutors, courts are overburdened. I'll be dealing with that little later. And therefore there is invariably a delay in disposal of the applications. Then comes High Court. Unless the accused is lucky enough to get bail from our Sessions Court, he has to approach the High Court. In bigger High Courts, listing of bail application is a big issue. Bombay High Court, that's a issue. We get petitions in the Supreme Court, direct Bombay High Court or Allahabad High Court to decide our bail application early. Allahabad High Court, same is the situation. That somebody comes and mentions before us, sir, my case is at serial number 1395, bail application, Allahabad High Court. So please do something about it. And last 30 years we have added new legislations, NDPS Act, then UAPA, PMLA. All these acts, there are stringent conditions for grant of bail. The courts are supposed to go into the existence of prima facie case, record finding one way or the other whether prima facie case exists. And you know kind of people who are involved in PMLA, for example. Now bail hearing in our system used to be very simple and very short. But today, sadly, I see reply rejoinder, surrejoinder culture being brought into bail jurisdiction. Now, so much of time is consumed of the courts in dealing with such matters where court is required to go into the prima facie case. And so much of time is consumed in these UAPA, PMLA, NDPS cases where the burden is on the accused to prove something for getting bail. The regular bail matters get backseat. Very classic thing I want to tell you. If you see old orders passed by Bombay High Court in appeals against conviction, where the accused was on bail during trial, there used to be a very simple order, admit same bail. No reasons were required to be given. Nobody questioned the high courts for granting bail or suspension of sentence in such cases. Now, today we have a very peculiar scenario, and I must blame myself for that. Our high courts and sessions courts, they have to do tightrope walking. There are cases when we get in Supreme Court where a very detailed analysis of material forming part of the charge sheet is made. There are prima facie findings recorded. Sometimes we end up in telling those courts, what is all this? What was the necessity for you to go into all these details? This is not the correct approach. There are cases where short order is there. We always criticize the courts that we are writing very cryptic orders granting bail. So it's a tightrope walk. 20 years back or 25 years back, I don't think any matter, Supreme Court has taken a view that why are not recorded reasons for granting bail. Of course, now these new laws have come, courts are required to record reasons. And result of all this is that we the judges face a lot of criticism that people are not getting bail in deserving cases. Personally speaking, from my experience, I cannot deny that there is an element of truth in this allegation. While I am on this topic, I must deal with the issue of media trial. It's not only media trial now. It's a trial through social media, trial at various levels. I have always said on public platforms that every citizen of India has right to criticize judgments of all courts. But that criticism has to be constructive. Those who want to criticize the judgments must say where the courts have gone wrong. But this media trial or trial on social media platforms, trial on other platforms is something which is different. And why it is different, I'll tell you. My perception, I have been chairman of the Legal Services Authority. I have traveled across the state, addressed seminars on legal literacy. All this happens because even educated people, including those who are in media or those who are on social media, they lack elementary knowledge of basic concepts of our criminal jurisprudence. They don't understand difference between grant of bail and acquittal. If there's a bail granted in serious case, criticism is made that as if person has been acquitted. And at all levels, people do not know what is the concept of, what is the jurisprudence as far as criminal matters are concerned. Very few know about presumption of innocence. In a lighter vein, I remember I had seen a beautiful comedy film in Marathi. It's all on one court case. It exposes the system. The hero, while addressing the court, tells the court that in our country, there is a need to educate educated classes. So when we talk about basic concepts in criminal law, I always remember what that hero said in that film. Few months back, I went to a local bar association in Karnataka where they wanted interaction with me. I prefer that. So one young lawyer got up and he said, I want to ask you one question, very peculiar question. And I'm sure almost all judges will face this some or the other day. The question was, when you means judges, when you sit in the court, you know that a person has committed offense. How can you grant order of acquittal? Then I have to explain the basic concept. And this basic concept, most of the citizens are unaware. Same question was put to me when I addressed Association of Gynecologists. They conduct legal seminar every year and they do a great job. So in an interactive session, same question was put to me by a very senior doctor, that don't you understand that person before he has committed an offense, but you let him off? So I had to tell them the basic concept. I told them what is the job of a judge who sits on the criminal side. On his perceptions, he cannot take a decision whether the person has committed an offense. His job is, in that sense, not to decide whether person accused before you has committed an offense. His duty is to see the legally admissible evidence on the record, and after appreciating that evidence, after considering the legally admissible evidence, he has to take a call and record whether the guilt of the accused is proved beyond reasonable doubt on the basis of available evidence. As a judge, we can't go by our perceptions. We can't go about what social media says, what the victim says. Duty of the judge is to grant conviction only if there is legally admissible evidence which proves the guilt. If you grant conviction only on the basis of perception when there is no evidence, it is moral conviction. Moral convictions have no place in our criminal jurisprudence. And this small perception about the job of the judges is very often misunderstood by the common man. It doesn't stop with media. Today, of course, after 77 years of independence, we see very heinous offenses committed in our society, offenses against women, offenses against minors, girls. When such offense is committed, we have political leaders who go on platforms and they say that not only that we'll arrest the accused, but we'll see that accused is hanged. And that is echoed in social media. Common man also feels the same way. Look at the offense. Such person should not be spared. He should be given capital punishment. And someday we'll have to tell these leaders that, look, it is only the prerogative of the courts to decide what punishment is to be imposed. And for that, there are well-settled rules laid down by our courts. But this has all the effect on the minds of the common man. I want to make little diversion here. There are many cases we come across where trial courts impose capital punishment. And in so many cases, maybe High Court or maybe Supreme Court has to let off the accused, not only for benefit of doubt. There are cases where we grant acquittal because there is no legal evidence. But in such case, there is a capital punishment. As a student of law, not as a judge, even today, a case comes before me, which is rare of rare cases, it will be my duty to impose capital punishment. But as a student of law, I feel that we must seriously introspect on one thing, or legislature must introspect seriously on one thing, whether in our system there should be a capital punishment. The reason is that our justice delivery system is not foolproof. There is always a margin for error. And secondly, we must also examine whether capital punishments have proved to be deterrent. And third and most important thing, after 75 years of existence of the Constitution, it's an issue for debate, whether the state can take away somebody's life. These are the three issues. On some other day, we'll have to deliberate. But time has come to deliberate upon that. And now coming to the bail under special statutes, of course, PMLA, UAPA, bail applications are fiercely contested, and there is nothing wrong about it. Because if you see academically, the offenses under PMLA, offenses under UAPA are really serious offenses. They threaten the entire nation. But sometimes we tend to forget that even prosecutors have to be fair. Of course, the trend keeps on changing. Those who are students, all of us are students of law. We see, even in Supreme Court, the trends keep on changing. Sometimes we go from one end to the other. And maybe I read some articles where they say that trend is changing for the good. I am nobody to say anything about it. Somebody else has to say it. But it is necessary to remember that though there may be stringent conditions for grant of bail under these statutes, where there is violation of Article 21, these stringent conditions should not come in the way of grant of bail. Now, the main thing which ails our system is huge pendency. Now, first and foremost reason for this is low judge-to-population ratio. In 2002 order of the Supreme Court, the court says that within 5 years, we should have judge-to-population ratio of 50, so 50 judges per million. And at that time, Supreme Court was considering the pendency and filing in 2002. Now, filing has multiplied. There are new set of offenses. Before I deal with pendency, I must say there is one provision which has affected our justice delivery system, that is 138 of Negotiable Instruments Act. You go to any court in Bombay, magistrates court or any bigger city, the magistrates are crumbling under pressure because they have to deal with these kind of cases, 138. We have made a civil wrong into a criminal offense. Of course, it's ultimately prerogative of the legislature. So first and foremost reason why there is a huge pendency is we are not able to maintain a decent just to population ratio. So in 2007, it was expected to be 50. Today, we are struggling. Last year, I think, Honorable Law Ministers stated on the floor of the Parliament, it is like 23. Figures keeps on fluctuating between 22 and 24. I'm following the statistics which is available. It is still 24, something just 10, we should have been 50. In 2007, we are at 24. And look at the fact that filing has multiplied. In fact, very interesting thing happened, I think, in 2016 or 17. I think Professor Mohan Gopal was appointed as a chairman of the NCMS. And Supreme Court passed an interim order in terms of the report of NCMS. Professor Mohan Gopal laid down a formula, and the direction of the Supreme Court was, you work out the required just strength on the basis of that formula and submit proposals to the state government. I was the chairperson of the Case Management Committee of the Bombay High Court. I found that if we go by that formula, the figure will be very high, 12,000. So somehow we made our own calculations, brought it down to 8,000. And I am told that this was done, I think, in 2016 or 17. I think barely 10% strength has been added. It's very easy to talk about increasing just strength, but only by increasing just strength, we don't solve the issue. Because we need corresponding infrastructure, we need court complexes, we need residential premises, we need administrative staff, we need prosecutors. And talking about this state of Maharashtra, we struggle to get infrastructure from the government. If you see the orders passed by Bombay High Court during last 10 years, at least 15 district courts have been constructed on the basis of orders passed in PIL. And the situation of infrastructure, of course, to some extent, I see a change during the last 5 years, change for the good. But the situation is such that one of the benches of the Bombay High Court had to write 200 pages judgment on infrastructure. And Arun Shourie, one of his book is regarding his wife getting bail. He has used that judgment and said that, look, this is the judgment of Bombay High Court. And it's a very sad story to tell that we lack basic infrastructure. So it's very, very difficult to get infrastructure from the government. I have been part of Bombay High Court, I have been part of Karnataka High Court. In Karnataka, situation exactly reverse. Whatever the court wants, government gives. And therefore, if you go to some of the courts in Karnataka, you will find far better judicial infrastructure. I remember when I was Chief Justice, some of the members of the Bar Council came to me. They said that we want to go and see the court complexes in Karnataka. I said, of course you can go and see, but on one condition, that don't go back and give trouble to the Chief Justice of Bombay High Court. Because there in district courts, there is a separate building for bar associations. There is a hall for holding functions. And some of you, if you get time, please go to Kalburgi High Court bench complex. It's a huge complex like a 5-star resort in Goa, where you have artificial lake, you have sandalwood garden, you have theme park, everything inside the complex. But scenario in our state is completely different. So increasing the just strength is easy. Even that easy thing is also not happening. That's a different thing. But from where we are going to bring infrastructure? We struggle to maintain the infrastructure. Go to civil court in Pune. I don't know what is the scenario. Justice Revati may be better aware of that. There were 10 courts of civil judge senior division who have unlimited jurisdiction. And they were sitting in one room. That one room was their chamber and courtroom. Morning and afternoon it used to become their chamber, and whole day it was their courtroom. So increasing the post is not going to solve the issue. There is one more concern. As a judge of the committee which headed recruitment committee of Bombay High Court, or Chief Justice in Karnataka has seen that. In Karnataka in 2020, in pandemic, we conducted not one but 3 processes of appointing civil judges. We could not get sufficient number of candidates. And of course, the things are changing now. In fact, I must share for your benefit, after Chief Justice Chandrachud's order, now the remuneration which a civil judge gets is quite reasonable. In fact, other day I was in a meeting with senior IAS officers, so all of them complained that they said, sir, do you know, a young law graduate who has not even seen the face of the court, he becomes a civil judge. That's what is permitted under Shetty Commission judgment. Now he is getting about 15 to 20,000 more at the entry point than what IPS or IS officer gets, and some more benefits. Education allowance, driver allowance, this is what civil judges are getting. So in some states like Maharashtra, Karnataka, we find difficult to fill in the posts. But look at the other side. I went to Bihar to deliver lecture in Bihar Judicial Academy. There were about 300 judicial officers who were appointed between 21 to 24. Out of them, of course, now that's a scenario in every state, more than 50% are women, but about 24 of them were alumni of national law schools. So in northern states, we are getting good candidates, but Maharashtra, Karnataka, I think same is the case with Tamil Nadu. Even if we have posts, how we are going to encourage our young lawyers to join judiciary? That is again a challenge before us. But forget about that judgment of the Supreme Court. What I feel is that we should not be too ambitious, but we must definitely make an attempt to achieve just to population ratio of 50. Another issue, another ailment is absence of public prosecutors. There are many states in India where there is one prosecutor for 2 or more courts. So result is, even if 2 courts are criminal courts, they have one prosecutor. So on a given day, that court cannot do any trial work. This is very common, very common. And there is lack of sensitivity about it. After I became Chief Justice of Karnataka High Court, there was an opening function of a court building. By that time, I was not conversant with Kannada language. Honorable Law Minister spoke, and completely bypassing the provisions of CRPC, he blamed the High Court for not appointing public prosecutors. He was not even aware that prosecutors are appointed by the government. Of course, that helped me. Next day, I initiated suo motu PIL and ensured that about 70% of the posts are filled in. So if there are no public prosecutors, how trials are going to be conducted? So this is a very serious issue, and I'm not talking about the quality of public prosecutors, because there also the selection procedure, the remuneration, these are all areas of concern. Another issue is, in our country, is one I said, 138 of Negotiable Instruments Act. It is one category of case which has led to docket explosions in all major cities. Another aspect which we must make a note, during last few decades, society has undergone change, especially drastic change in urban areas. Now matrimonial disputes are on the rise, and one matrimonial dispute not settled at the threshold gives rise to at least 3 cases in criminal courts. One is 125 of CRPC for maintenance, one is domestic violence section 12 complaint, and third is of course 498 and other sections. Recently there is one addition to that. The husband and wife exchange WhatsApp messages, so there is prosecution under IT Act also. So one matrimonial dispute leads to 3 cases, 3 criminal cases at grassroots level, and then those revision applications, quashing petitions, appeals, revisions, up to Supreme Court transfer petitions and whatnot. So these are the cases which have really destroyed our criminal courts. I mean, courts are crumbling under pressure. And of course, it is always that criticism about 498A, that 498A and provisions of Dowry Prohibition Act are misused. And those who are part of the institution, they will say that it is really misused. But there is other side of it. I have been visiting villages as part of the legal service authority setup. The real issue about 498 cases is different. What we see are the cases, maybe some of the cases are frivolous, of course. And ultimately, we must remember one thing: who advises the wife to file case under 498A? The members of the legal community. They advise the wife, where they know that if they want to bring the husband to table for settlement, such cases are necessary. But if you go to rural areas, our slums, you will find that there are genuine cases of 498A where women suffer cruelty and harassment in connection with demand of dowry. But they silently suffer that injustice because they can't come to the court. social conditions, economic conditions, and various other reasons. So when we talk about 498A, of course, we must acknowledge that some cases are frivolous, but we must also acknowledge that there are many cases where women silently suffer injustice. And this is happening 77 years after the independence. Another issue is about legal aid. As all of you know, right to get legal aid is part of Article 21. Article 22 also supports that. And therefore now we have network across the country under the Legal Services Authorities Act. There are legal aid lawyers who go to jails and sub-jails. There are legal aid lawyers who are available when accused is produced for remand. There are secretaries of Taluka and district legal service authorities who keep on frequently visiting the jails. It is their duty to see that bail applications are filed on behalf of accused who are languishing in jail, appeals are filed. And now we have added that some other work for the legal service authority, that those accused who are entitled to remission under section 432, even their applications must be filed by the legal services authority. So there is a network available. There is infrastructure available. What we are worried is about the quality of legal aid which we are extending. I'm not branding every legal aid lawyer that he is incompetent, but those who sit in the courts as judges, Sessions Court, High Court and Supreme Court, we see that very disturbing thing. In fact, one of the benches of the Supreme Court, you must have read in media, that one of the benches of the Supreme Court commented that legal aid given to poor is also poor. So this is a concern. Legal aid is a major concern. Many cases I come across, I am dealing with most of the criminal cases, mostly appeals on Thursdays, appeals against conviction. That basic cross-examination of the witnesses is not made by the legal aid lawyers. If legal aid lawyer does not understand how to bring contradictions and omissions on the record, what will be the quality of that cross-examination? And on this aspect, I must say something. Some innovative provisions have been made. For example, section 372 of CRPC was amended and unqualified right was given to a victim or first informant to challenge order of acquittal. If government wants to file appeal against acquittal, government must take leave. But appeal by victim is as a matter of right. But there are grave limitations on that. If there is no proper evidence adduced, if the witnesses have not supported the prosecution, such remedies don't serve any purpose. So same thing, there are cases and cases where we find that there is no proper cross-examination and therefore there is a conviction. Of course, I must compliment members of the bar of Bombay High Court and Supreme Court that whenever we feel that issue is complicated, we request the members of the bar to assist us and they assist us. Sometimes I wonder whether Bar Council should frame a rule or there should be amendment to section 16 which will enjoin every designated senior advocate to take up at least 5 criminal cases every year. That should be a condition for designating a senior counsel, or even the senior advocates should practice on the civil side in our trial and district courts. They should be told to at least take up 5 cases, 5 or 10 cases also. Another issue is what happens after conviction. As you know, there is a conviction, maybe after long drawn trial, then there is appeal filed. Now there are 2 categories of appeals against conviction which are pending in the high courts. One category is where accused is on bail and other category is where accused is denied bail. Naturally, we give priority to the appeals where accused is in jail. But what is happening is that the appeals where accused is on bail take backseat. And in Bombay High Court, in Allahabad High Court, other bigger high courts, I can safely say that where accused has been convicted under 302, but he is on bail in appeal, cases are pending for 20 years. In fact, if you go to the statistics of Bombay High Court, 8,200 appeals, criminal appeals are pending in Bombay High Court, the principal seat, and 7,190 are before division bench. So what happens is, accused who are enlarged on bail, their appeals go in cold storage, and then we face grave difficulty when appeal comes up after 20 years. Then we see that there is adequate material on the record to confirm conviction under section 302. And in almost all these cases where appeal comes up, after 20 years, the offense is 30 years old, incident is 30 years old. That by that time the person settles in life. And I do not know whether it is right or wrong. Then we adopt easy options. Then we tend to convert 302 into 304 part 1 or part 2, and then we say that we'll let off the accused on undergone. Yesterday one case came to me where the appeal against conviction in one of the high courts, I think Allahabad High Court, is pending from 1992. Because this is a very peculiar problem to Allahabad. Allahabad High Court works always with 50% strength. So this delay is working against a fair system. Sitting every day, we grant acquittals where somebody has undergone 10 years, somebody has undergone 20 years. We grant acquittal. In many cases, it's a clean acquittal, not a benefit of doubt, etc. I always wonder what happens to the accused who undergo sentence for 10 years, 15 years. We are hardly aware about social consequences of branding a person as accused or arresting him and putting him in jail. I remember I had visited Nasik Central Jail and I think one more jail, I forgot which jail, as chairperson of Legal Service Authority. I had interaction with social workers. The social worker said, sir, these prisoners have one concern, how to get their daughters married. The stigma is attached to the entire family. Their sons and daughters, their children don't get jobs because the entire family is branded. So this is going to create serious issues. Somebody will come up and he'll seek compensation against the state. We don't know whether he can seek it. That's a different area. It's for courts to examine. But then somebody has to consider this 10 years or 15 years in jail and thereafter acquittal. So therefore, if you look at the system, the victims are victims of the offense, the victims are the accused also. And day in and day out we see people are being framed, there is no evidence against them. I remember one case in 2005, I had long sitting of 6 months for bail. There was a case under section 302 and after reading section 161 statements, I refused bail. Then second bail application came. Second bail application comes before the same judge. The facts were startling. The widow of the deceased filed a petition under Article 226 before the High Court. High Court appointed a senior IPS officer to do further investigation. Further investigation revealed that the accused to whom I had denied bail were not the accused. Somebody else was the accused. This is not a solitary case. This happens day in and day out. Now, we talk about this delay in getting the cases listed. There are two reasons for that. One reason is we don't adopt proper case management techniques. And I'm not saying something which cannot be done. Those who used to appear before me, they will know that from 2007 to 2019, I used to start my cause list at 11 o'clock at that time. The reason is that there was a date system introduced by me where nobody was required to mention the matters. And then we carried forward this system in Karnataka with the help of my very good colleagues there. Mind you, in September 20, we started auto-dating of the fresh cases, which provided that on 4th day, every bail application will be listed on the board, even if objections are rectified or not. 3rd day, the anticipated bail, and all other cases on 7th day. And we introduced it and we implemented it I had told the members of staff that even if one case is not listed, concerned officer will get the memo. And the system worked beautifully in the sense that from September 20 to August 21, when our court was working full-fledged, the disposal, except in May, disposal was more than filing. This was the result of auto listing of the fresh cases. And I am happy to note that, of course, after I was elevated to Supreme Court, that practice was discontinued. But the present Chief Justice of Bombay High Court, Justice Alok Aradev, when he became acting Chief Justice in Karnataka, he reintroduced that system. And I hope and trust that he does that in Bombay High Court also. If we had that system where there are auto listing of fresh cases, most of the issues regarding listing will be sorted out. Of course, I had told the members of the bar that I will ensure that your bail application is listed or quashing petition listed on 7th day. But if you seek adjournment, then it is for the judge. He may grant date after 2 months. That is your luck. But we need to take very innovative measures. And second and most grave area is that we are not able to set our priorities right. Which cases should be given priority? We don't have a definite policy that which cases will be given priority. Now we have a policy that when accused is on bail, we will not give priority to his appeal. For practical reasons, there are no scientific reasons for that or well thought about reasons for that. So there is no policy fixing the priorities. I have given you the figures of pendency on the criminal side. Now these are all human rights issues on the criminal side. Now when we have such a huge pendency, can we say in country like India that commercial matters and arbitration matters should be given priority? I am not saying that they should not be given, but this is a question we should be asking to ourselves, because we don't have priorities fixed. Some scientific exercise is required. Now there is one judgment of the Supreme Court which says that cases of senior citizens, means those who are above 60, should be given priority. In Bombay High Court, I'll give you an example of Bombay High Court. When second appeal comes to the Bombay High Court, both the parties, the contesting parties, are second or third generation of litigants. Now the question which I used to always ask myself, should we give priority to a case of a litigant only because he is 60 years old, and we should ignore those cases where second and third generation of litigants are fighting? It used to happen in matrimonial matters, in family court appeals. Perhaps it happened when Justice Revati was sitting with me. There was one application was moved. The lawyer said, sir, both husband and wife are more than 60 years old. It was a matrimonial dispute, family court appeal. So I said, how can you give priority to matrimonial appeal, family court appeal, because somebody more than 60? We should be giving priority to cases of litigants who are in early 30s. So everywhere, I'm not saying our priorities are going wrong. We have not thought about the priorities. And one more area where we don't care about the priorities, that for that, we the judges and Supreme Court and High Court must take blame. A case comes up before us, we want to deny bail, but we want to satisfy the lawyer also. So we reject the bail application and say that conduct trial within 6 months, without knowing that even charge is not framed, without knowing that in that court there are 10 years or 15 years old trials are pending. We do that sitting in the Supreme Court. Somebody who can afford to come to the higher court, he walks away with such order. I am very candid, I am sorry about it. There was a dispute between two groups of trustees of one particular trust in Bombay. My experience was that every time the case came back from Supreme Court, it used to come with time-bound schedule. Some of the senior lawyers will understand which is that case. I used to always get disturbed. I mean, how this could happen? Two groups of trustees are fighting. Why such case should be given priority? Of course, now there is a judgment of Allahabad Bar Association Constitutional Bench judgment, where finally Supreme Court has said that we should not tell any other court to decide cases on priority basis or within a time-bound schedule unless it is of exceptional nature. But notwithstanding Constitutional Bench judgment, today also we get those orders sitting in the Supreme Court, finish trial within 6 months, 8 months, where we don't know that there are 100 witnesses, how trial is going to be over within 6 months. So this is also part of the same thing, that we are not able to decide about our priorities. See, priorities may differ from one state to another. Priorities may differ from one court to another, but we need to have a look at it. Other thing, again, these are my strictly very personal views. Last 75 years, on many platforms, we discuss justice, we discuss courts, but we discuss only about high courts and supreme courts. We have completely neglected. We means those we sit in the higher judiciary, maybe as judges, maybe as lawyers practicing before the high courts and supreme court. But we have forgotten that our trial and district courts are also constitutional courts. We never discussed our trial courts. We never considered difficulties of our trial courts. If you see Articles 233 and 237, you will realize that even these courts are constitutional courts. The service conditions of the district judges and civil judges are laid down in the Constitution. But for all these years, we kept on branding these courts as lower courts or subordinate courts. This is most unfortunate part of our system during the last 75 years. Because these are the courts of common man. These are the courts where common man expects to get justice. But we are not thinking about that. Of course, of late now, things have started moving. Now we are recognizing our trial and district courts, but we have not given importance to these courts during the last 75 years. Therefore, to conclude, now time has come when legislature, the judiciary, the law enforcing agencies, the judges and members of the bar have to take up the challenge. As I said, the system suffers from too many elements. And when a person suffers from too many elements, he becomes a patient which is very difficult to manage. I don't think situation is so bad. If all of us come together, the patient can be managed. One more thing on which a lot of rethinking is required. I have been attending seminars, speeches during the last about 75 years. Those who are connected with judiciary, maybe lawyers, maybe judges, we keep on saying, common man has great faith in the institution. But if you go to trial courts, if you go to high courts on the other side, and if you talk to litigants, perhaps you will realize that what we say about litigants having great faith in the system may not be correct. And this is one area where we are not accepted, where we have gone wrong, or where we have fallen short. And therefore now time has come after 75 years of existence of Constitution to accept where we have gone wrong. Well, unless we accept that we are going wrong somewhere, we can't think of improving the system. I think I can go on and go on. 21 and a half years as a judge of 3 constitutional courts is a pretty long time. Many thoughts come to me, and there are many experiences to share. But I think somewhere I must draw a line and I must stop. This is just an overview of my thoughts. My idea is to ensure that everybody starts thinking. As I said, what I said may not be exactly correct, but these are the impressions which I have in my mind. And during the course of what I said, I have given few ideas also about case management techniques. Of course, that's a topic for a separate lecture. What should be the ideal case management techniques? So I again thank the office bearers of the Bombay Bar Association. They have given me this great opportunity to speak before such illustrious audience. I mean, the senior lawyers, the senior judges, they have been my idols, and it's a great pleasure to come before them and express my thoughts. So I thank the President of the Bar Association and others for giving me the opportunity. Thank you.
Justice Oak has graciously agreed to answer some questions if anybody from the audience would have some.
Answerable questions.
I'm sure the audience heard that. So please ask questions which are answerable.
Sir, artificial intelligence, if it is come in the legal system.
So the question is how far artificial intelligence is useful. I'll give my candid opinion about it. With our research team, I sat. See, ultimately, artificial intelligence will give the result depending upon data, and most of the results can be misleading. Artificial intelligence will help us in case management techniques, in identification of cases, or at the most cases under Motor Vehicles Act where there's a formula laid down. But ultimately, we are talking about the criminal law. Only human mind can appreciate the evidence. Only human mind can decide whether a testimony can be believed. Artificial intelligence is not going to help us in this manner, in these matters.
Sir, I have a basic question. Would the reintroduction of the jury system improve the criminal justice system?
My answer is no. The reason is simple. The juries are not trained. They can't appreciate the evidence of witnesses. And their opinion will be based only on their personal perception and not on the basis of legally admissible evidence on the record. In fact, if we introduce jury system, of course I may be wrong again, this is a matter which requires debate. Perhaps it will be violation of Article 21 because ultimately courts will be depending upon opinion of those who don't have legally trained mind. And especially in criminal cases.
Yes, I have a question related to custodial death and how to get correction with respect to the encounters, the police death. What we have seen in Badlapur case and some other cases in India. So what are the ways to correct and what are the remedies to available as a common man, as a citizen?
See, it's a wider question. Of course, such things happen. I mean, nobody can deny that. But for that, of course, intervention of the writ courts, constitutional courts is required. But, everybody has to be alert. I'll give an example. When an accused is produced for remand, first remand, at that time the magistrate should be asking proper questions. Because these are the cases again where there will be custodial violence, etc. So at all levels we require improvement. Only by saying that court should intervene, that is not going to be sufficient. We will need sensitization of police forces. And, I talked about some time back, the demand comes that capital punishment should be given. These are the cases where sometimes the police have acted under enormous public pressure. So it's a very complicated issue. Mainly this arises because 75 years of existence of Constitution, we are still not aware about the fundamental rights. We are still not aware about the rights of detainees, rights of the victims as well as rights of the accused. So it's a combination of various factors, but correction will be required at various levels.
That's, if I may ask a candid question, 8 years back I was personally the litigant in infrastructure of High Court case, Malad pass a detailed order. Are you still believing on the state's solemn affirmation that they will make this dream true? Because we are in the 9th year of that order, Malads, and
Right.
we are still trying to make it happen.
Please ask me this question after May 25. I'll answer it correctly.
My lords assured us that the judiciary will take note of it. Of course, it's taking note of it, but
Right.
we still feel that should we buy a home in South Mumbai or in Bandra?
Yes. Greetings, sir. Of course, I would like to say that it was a very detailed and an insightful session. So there are a few observations that I have myself made as an assistant professor of MNLU Mumbai. So I have introduced one course on forensic science, and it is after years of maybe some research that we've done, that the bail jurisprudence that we keep on talking about, these days the trend is that it is mostly the history sheeters who are going out and committing the offense while out on bail. So my first question is that whether monitoring of people who are out on bail, maybe through technology or maybe in some whichever manner quite possible for us to maybe monitor them, will help. And my second question is in terms of reliance on forensic evidences. Do you, sir, believe that since after going through all these kind of criminal investigations, we have come to a conclusion that sometimes the witnesses might as well turn hostile, but the forensic science and the backing of forensic scientific evidences, would that you feel would make the system robust?
First thing which you said about hardened criminals getting bail and they committing offences after being released on bail, I think it's too general a statement for which we need data. That in a particular year, how many accused who are facing charges of very serious offences were enlarged on bail and how many of them have committed offences. So without data being available, we can't draw such conclusions. And about forensic science, I mean, there are few areas where the evidence of the forensic science laboratory is conclusive. It doesn't depend upon whether the witness has turned hostile. So there are well-defined areas where the evidence is conclusive. But there again, difficulty, I'll tell you the difficulty. For example, take NDPS case. There will be a report of forensic science that this is a particular contraband, maybe charas, maybe ganja, any other contraband. But that itself is not sufficient to convict the accused because ultimately the prosecution has to prove that it is the same contraband which is analyzed by the laboratory, the same contraband which was recovered from the accused or from the house of the accused. So there lies the limitations on the evidence in the opinion of the FSL.
Your Lordships, you had mentioned that the Negotiable Instruments Act especially, it is more of a civil kind of wrong than criminal. My question is with respect to Domestic Violence Act, and if I recollect correctly, your Lordship had an observation with respect to Domestic Violence Act that it is more of a civil enactment. So will it be proper if domestic violence cases are also looked from a civil perspective more than from a criminal angle?
See, that observation was in completely different context. The issue was, when I studied the provisions of that act, there is only one penal provision by which a public officer can be penalized. And therefore, it was in different context. The issue was whether 482 power can be exercised for quashing a complaint under Section 12. I will not dwell upon it more because same issue I am supposed to decide within few days. But that was in that context, the context of 482 jurisdiction.
Looking forward for that issue. Thank you very much.
Your Lordship, why the accused was being taken out to enact a particular crime scene? In that case, encounter deaths happened, particularly in Maharashtra and in Telangana. Can we dispense it off?
I have not understood your question.
Why the accused is taken out to enact a particular crime scene? During that time, police kill the accused. Can we dispense it off that act from the police manual?
See, there are different issues about it. Whether recreation of crime scene, whether it can be part of the investigation is an issue.
Can it be dispensed off?
No, this issue will have to be decided someday. Whether this can be part of the investigation, that is number one. Number two, again, you are talking about a particular case. Where
it happened in Telangana and also in Maharashtra.
Ultimately, we have to go by the facts. What is the material on the record to show that the accused were killed when they are taken out to recreate the crime scene? It all depends. It should not happen. But today, I am not able to comment upon whether recreation of a scene of crime, recreation of crime,
is it not
can
unnecessary?
be part of the investigation. That's an issue which will require examination. And frankly speaking, I have not applied my mind to that. But that will need examination someday. Because this is a new trend that we see on the criminal side.
Thank you, sir.
I'm sorry, may I just ask one question here, sir? I mean, I must say that a lot that I heard today sounds like an echo for me. with all the years that I've also spent in this branch of the law. But the new statute now provides for trials through video conference, and therefore witness actions will now to a large extent be also possible through VC. Now, in the context of the Evidence Act and the question of appreciation of evidence, demeanor of witnesses, etc., do you have a view on how this will impact criminal cases, and to what extent we should allow all kinds of witnesses to come on VC, or only certain types of witnesses who may be formal in nature to be through VC? Because now technology is coming into new legislation. So when we are dealing with this aspect of appreciation of evidence, what is your sort of sense of the matter?
Actually, this issue requires a lot of debate. We don't have a robust system today. And I always wonder, especially in criminal trials, the appreciation of evidence by the trial courts also depends upon the demeanor of the witnesses, which the judge sees. It is not necessary. In some cases, judge would record that in the evidence, that he is hesitating to give answers, etc. But the facial expressions of the accused, the witnesses, not the accused, facial expressions of the witnesses, they are essential part of appreciation of evidence. Maybe a skilled cross-examiner would like to observe the expressions on his face, the way he is responding to the questions. Unless we have a very good system working, it is very difficult to record demeanor of a witness, for both for the judges and lawyers. But to begin with, there is no harm if we implement this system, at least for formal witnesses, so that a lot of time of the court can be saved. For example, there are police officers, they are transferred. All that they have to do is come and prove the Panchanama or some other document, some seizure memo, etc. So there is no harm if we start utilizing this system to curtail the delays. Whether the evidence of eyewitnesses can be recorded in this form, this requires debate. But in any case, we should start utilizing that for formal witnesses, or for example, expert witnesses like doctors, post-mortem doctor, or somebody who gives medical certificate. So we should start utilizing that provision. And someday, of course, we'll have to apply our mind. Legality will have to be tested, but at the same time, we should have proper connectivity, proper equipment.
I'm just making one more additional suggestion to what you just said, is maybe because we have different types of offenses which are summary, summons, warrant, and then the sessions trial. So maybe in cases of summary and summons, which may not be as serious, where we are able to actually fast forward, you might be willing to consider.
For example, 138 Negotiable Instruments
exactly.
Act,
So
all cases can be conducted through VC.
Exactly. But therefore, categorizing them on the basis of punishment, and then seeing if they are the more serious ones, obviously, demeanor becomes very, very important. But maybe in summary and summons cases,
so that is a good idea to classify the cases.
Correct. Because the large number of pendencies because of the summary and summons cases.
Right.
So that may be fast forwarded through this means.
And one more thing I just forgot to tell you. Last year, Supreme Court has devised action plan for our trial courts for disposal of old cases, more than 10 years old cases. And we are monitoring implementation of action plan on daily basis, virtually daily basis, and we are holding interactive sessions with the High Court judges. And now, as a part of that scheme, perhaps now the Honorable CJ has come out with the suggestion for evening courts. Now, of course, we have some members of bar do have reservations about it. But if we have this kind of a pendency, why can't this 138 cases or Section 12 DVAC complaints go before the evening courts? I mean, this is going to be part of our action plan. And that
one more suggestion, if I may give just from experience, is that now that we see in trial courts, when we actually started practice, when in private complaints, when summonses were issued, there was no question of offering a bail when an accused appears before the court. Then we had the whole phase where every trial court would then say it's a non-available offense, apply for bail and you get bail. Now, your lordships have then started interpreting Section 88 to say that you can still take a bond and there's no need for a bail. The new law now has introduced a provision where it's a bond or a bail. Now, what happens is a lot of time in the magistrate's court and the trial courts is consumed in these kind of applications, because everybody is afraid that if I apply for bail, even when a complaint is filed, will I get bail or will not get bail? And every application, as we have seen, goes on endlessly in a bail matter which is unnecessary because they should actually focus on trials and other more substantive applications. So is there a way by which we can actually educate the trial courts, because we see this fairly frequently, not to insist on bail in these routine cases where summonses are issued and just get on with the main issues, because it's consuming
in fact,
a
we
lot
can
of unnecessary
use earlier
time.
judgment. Now law is very clear.
But the new statute
Right.
has created
Correct.
a problem.
But even that old law will apply. For example, in
should.
PMLA we have laid down
I know.
that if summons is issued, nobody can be arrested if he appears.
That's right.
And even if he does not appear and warrant is issued, he need not apply for bail.
Right.
He can apply for cancellation of warrant. I think same law will have to be applied.
should
But
apply.
you are right. I mean, I'll take up the issue because
Practical
I
realities are...
keep on visiting judicial academies. On this area, we need training. You are
It
right.
just saves a lot of time for the trial courts. Very good.
Thank you. That concludes the questions. I'd like to extend my deepest gratitude to Justice Oak for delivering such a thought-provoking and incisive lecture on what ails our criminal justice system. Your insights into the challenges afflicting our criminal justice system, whether it be delays in trial, access to legal representation, the burden on investigative agencies, or systemic inefficiencies, has given us much to reflect upon. By highlighting these pressing concerns, we hope that today's discussion sets the wheels in motion for a meaningful reform that would lead to a more effective and just legal system. A special thanks to Honorable Justice Dere for presiding over this event and for her unwavering commitment to justice. Your presence here today has truly elevated this occasion. I also extend my gratitude to Justice Gautam Patel for his eloquent introduction, which perfectly framed the essence of today's lecture. A heartfelt note of appreciation to the family of late Mr. Ashok Desai for initiating and steadfastly supporting this annual lecture series. This platform stands as a fitting tribute to his immense contributions to the legal profession and continues to inspire critical discussions on law and justice. This event would not have been possible without the effort put in by the Bombay Bar Association and our team who have made this possible. A big thank you to all of them. And lastly, to our esteemed guests, members of the bar, and all those present here today, thank you for your time and engagement. Your participation reflects a shared commitment to justice and reform. Thank you very much.